Nicole Reinhorn, MD versus Orthopedic Specialist of Northwest Indiana PC. Sunik Divya, MD Joseph Height. Knighton Kana, MD, and David Tyndall, 45 CO 11309 PL 93. For the record, who's here?
Your Honor, my name is Stephen Gistinson, along with Jim Weiser. I'm an attorney with a ProHack Vichy that's been issued by the state and is before Your Honor on a motion. Mr. Weiser is co-counsel, and Dr. Einhorn is in court with us.
Okay.
James Doherty, Your Honor, co-counsel for defendants.
Calvin Kushef, Your Honor, appearing on behalf of the defendants as well. My partner, Greg Moore, from the same firm, has also appeared in this matter. Mr. Moore is admitted to practice in the state of Indiana. I have submitted my request for a temporary admission. I have not filed my motion yet. We just filed it yesterday, but I have been previously admitted pro hoc vice in the state of Indiana as recently as 2012.
Your Honor, we have no objection to that.
All right. Are we ready to proceed?
Yes, Your Honor.
All right. Let's proceed.
Your Honor, good morning. Stephen Gistinson on behalf of the plaintiff. Your Honor, may I inquire of the court whether the court would simply like argument on this TRO motion, or if the court would ask that testimony be presented? Dr. Einhorn is in open court and we're prepared to present testimony.
Your Honor, I believe that today would be more appropriately handled with just argument.
All right.
Thank you.
Let's argue it.
May I proceed?
Yes.
May it please the court. Your Honor, the plaintiff appears before this court this morning on an emergency motion for temporary restraining order and preliminary injunction, arising out of a series of acts and actions that have occurred over the recent weeks. With respect to the plaintiff in this action, or pardon me, with respect to the defendant in this action, Orthopedic Specialists of Northwest Indiana, PC, which we sometimes refer to as OSNI, O-S-N-I. Your Honor, OSNI is a professional corporation organized under the laws of the state of Indiana. It owns and operates a licensed medical facility in the state of Indiana and provides the services of its physicians in orthopedic medicine and surgery to patients residing not only in Indiana but also in Illinois and in other states. These are facts, Your Honor, which I'll refer to that are alleged in our verified complaint. Dr. Einhorn, Your Honor, is a board-certified orthopedic surgeon specializing in hand and upper extremity surgery. Stated simply, Dr. Einhorn is a hand and wrist specialist, and she is the only one at OSNI who is a hand and wrist specialist. She has conducted her medical and surgical practice in Munster, Indiana, serving patients served by OSNI and served by referring physicians and referring entities that have been sending patients to OSNI and specifically to Dr. Einhorn for the last over 13 years. Dr. Einhorn, as well as the other individual defendants who are named in the verified complaint, are shareholders of OSNI. And, Your Honor, the way that the OSNI Corporation operated was that these shareholders each executed an employment agreement with OSNI. And as Exhibit A to that employment, each shareholder executed a document entitled Restrictive Covenants. And among other things, that document contains in it a covenant not to compete. Since Dr. Einhorn joined OSNI in May of 2000, there have been several different employment agreements, and the most recent employment agreement is from 2010, and a copy of that employment agreement is attached to the verified complaint and as well to the motion, which has the verified complaint, as Exhibit A, or pardon me, Exhibit number 1. The restrictive covenants to which I refer are attached as Exhibit 2. Your Honor, in June of 2013, just a few months ago, Dr. Einhorn submitted a letter to the Board of Directors of OSNI. The Board of Directors of OSNI is comprised of the shareholders of the company, Dr. Einhorn and the individually named defendants, as well as one other doctor who is a shareholder. His name is Dr. Glick, G-L-U-E-K, who is not named as a defendant in this case. The Board of Directors met on June 19, 2013. Dr. Einhorn at that time submitted a letter to the Board of Directors that made a proposal. And we've attached this letter as Exhibit 3 to the verified complaint and restated the letter in full in the complaint because, as Your Honor will see, it is that letter that forms the basis for the parties' various positions in this case since June 18, 2013. In the letter, which isn't long, Dr. Einhorn states that, at this juncture, I believe it's best for all concerned that I separate from the group. Dr. Einhorn stated in her letter, Exhibit 3 to the complaint, I request that I do so under the same financial terms that are being offered to Louis Glick, M.D. That's the other shareholder whom I mentioned, Your Honor, who is not an individually named defendant in this case. Dr. Einhorn wrote that her attorney will contact the company's attorney or whomever the company designates or the group designates to complete these arrangements referring to the terms of a separation from the group. And Dr. Einhorn wrote that she'd like to complete this as quickly as possible. She hopes that this can be amicable, expedient, and that a separation can be achieved. That's the sum total of the letter that Dr. Einhorn sent to her partners, to the group of shareholders that make up the partners in the Board of Directors of OSNI. What led up to this letter were various issues that had been brewing within OSNI. Among other things, the partners, they called themselves partners, they were actually shareholders. The shareholders had disputes concerning recruiting of new physicians to OSNI. They had disputes concerning the discipline of surgeons or physicians at OSNI, including one of the shareholders of OSNI. Dr. Einhorn had concerns about what she perceived to be violations of this position, of various rules and regulations that apply to OSNI, and she raised those concerns, and she was dissatisfied with the way that was handled. And she was even concerned that if her concerns weren't heeded, if something wasn't done about those concerns, that there may be an issue and there may be exposure. So those are an example of some of the issues that arose that led Dr. Einhorn to submit her June 18, 2013 proposal. Dr. Einhorn delivered that proposal at a board meeting on June 19th, and pursuant to the request of a member of the board, she also emailed that letter to the members of the board, and then she heard nothing. They ignored her proposal. They wouldn't even accept a physical copy of the proposal during the June 19th board meeting. It was just ignored. The next thing that happened with respect to her proposal for a separation was that on August 7, 2013, out of the blue, Dr. Einhorn received a certified letter from OSNI, from the individual defendants who are named in this complaint. That certified letter is significant because Dr. Einhorn's letter was something that she handed to the board. It was a proposal for a separation, yet in this certified letter, which is attached to our complaint as Exhibit 4, OSNI, these individual defendants, said, we acknowledge your resignation from June 18, 2013. It's significant, Your Honor, because on the face of the June 18th letter, and all other evidence that will be presented in this case, that June 18th June 18, 2013 letter by no means constituted a resignation. It doesn't say it's a resignation. It doesn't indicate that Dr. Einhorn wants to resign to what would be paragraph 5 of her employment agreement. The employment agreement is Exhibit 1 to the verified complaint. It makes a proposal and specifically refers to a separations under financial terms to be agreed upon between Dr. Einhorn's attorney and the corporation's attorney. Moreover, Dr. Einhorn's letter wasn't sent to the corporation by certified mail, and that's only significant because it's further evidence that this by no means, this June 18th letter, Exhibit number 3, was by no means a resignation of Dr. Einhorn's position with OSNI under her employment agreement. Nevertheless, for whatever reason, OSNI, through the individual defendants, decided that they didn't want Dr. Einhorn to be a part of OSNI anymore. And they undertook actions which were part of a plan to force her out of OSNI. And Judge Pierce, not just to force Dr. Einhorn out of OSNI, but to force Dr. Einhorn out of OSNI in a way that she wouldn't be able to practice medicine or practice her surgical practice in the community where she's been practicing, the only community where she's been practicing for 13 years. What the OSNI board, other than Dr. Einhorn, what these individual defendants did is they said, we accept your resignation, thank you very much. Here is what happens under the executory terms of your employment agreement, Exhibit number 1. And by the way, you now cannot practice medicine within 15 miles of any operations conducted by OSNI for a period of 2 years. So there were two things that they want to do. They want to get her out of OSNI, and they want to prevent her from practicing her livelihood for a period of 2 years based on this supposed resignation. The reason that fails on the face of the employment agreement and on the face of the June 18th letter is because the June 18th letter isn't the resignation letter. It's clear on the face of the very document. The reason it fails is because, for whatever reason OSNI wants to force Dr. Einhorn out, it's not pursuant to any provision in the employment agreement. It's not a voluntary withdrawal, as stated in paragraph 5 of the as stated in paragraph 5 of the employment agreement. It's not a resignation. They can point to nothing where Dr. Einhorn states that she's resigning or anything other than, I want a separation under terms to be negotiated that are the same as Dr. Glick. And by the way,
what terms were those that Dr. Glick?
I was just going to get to that, Your Honor. The terms are significant because what Dr. Einhorn wanted and what Dr. Glick had, as alleged in the complaint, is a negotiated agreement whereby she would no longer be a shareholder, but she would continue to practice her, or continue to carry out her surgical and medical practice as a paid or salaried employee of OSNI, where she would continue to receive her personal receipts. The way they had this corporation organized, Your Honor, is that the individual physicians had personal receipts, and they also had receipts that they called ancillary receipts, like when they referred somebody to physical therapy or to some other part of the practice that the doctor didn't personally conduct, that she would continue to have her share of those. In other words, she would continue to be an employee of OSNI. She would continue her medical and surgical practice at OSNI. Those were terms that the corporation had negotiated with Dr. Glick, and as of the time Dr. Einhorn submitted her letter, the corporation, all of these individual defendants were prepared to move ahead with that arrangement with Dr. Glick, which, by the way, was another reason, another issue that compelled Dr. Einhorn to submit the June 18th letter and say, I want a separation under those same terms. OSNI, after they got the June 18th letter, OSNI did not proceed with the Dr. Glick arrangement that had been negotiated. In fact, Osney's position is that Dr. Glick has now resigned. We haven't seen any document supporting the resignation. We don't know what arrangement Osney, through these individual defendants, have made with Dr. Glick, but it stands a fact that's uncontrovertible in this case that the only thing Dr. Einhorn proposed was this arrangement where she would continue to work at Osney. And the fact of the matter is, they never negotiated it. They never agreed to it. So the status quo is that Dr. Einhorn continues to be a shareholder and employee of Osney. But what happened after that August 7th letter tells a story about what the defendants were trying to do in this case, and it lays the basis for our claim that the defendants tortiously interfered with Dr. Einhorn's contract. The events that led up to the August 7th letter and the August 7th letter itself, we submit, is a breach of Dr. Einhorn's employment agreement. And the defendants, the individual defendants' conduct in this matter, we submit, constitutes tortious interference. What the defendants did after the August 7th letter, and even if we take the August 7th letter and the defendant's position at face value that we accept your resignation, a resignation that was never given, they say in their August 7th letter, Exhibit 4, that your last day, your resignation will become effective on September 18, 2013. Well, that September 18th date cannot be found in Dr. Einhorn's letter. The letter didn't purport to give 2 years' notice, 5 years' notice, 90 days' notice, no period of notice, because it wasn't a notice letter.
Did the contract call for a notice provision? Was there a notice provision in the contract?
Yes, Your Honor. Paragraph 5 of the contract.
It was 90 days, from what I recall from the pleadings?
Well, there are different notice provisions. Paragraph 5 of the contract deals with a withdrawal, what they call it is for convenience, which is what a resignation would be.
Right.
And paragraph 5 does say upon 90 days notice. Then in paragraph 6, subparagraph C, I believe it is, which deals with what happens if somebody voluntarily withdraws or resigns, there are 3 different provisions. One that says if you leave within 5 years, or if you give 5 years notice, you get these compensation benefits. If you give 2 years notice, you get these benefits. And if it's less than 2 years, you get these benefits. So there are different notice provisions of the contract. But of course, in Exhibit number 3, the June 18th letter, none of those provisions are referred to. No notice period is referred to because it's not a resignation and it doesn't purport to be a resignation. After August 7th, which happened to be a day that the defendants knew Dr. Einhorn was driving to North Carolina for a previously scheduled vacation, on August 7th, they delivered that letter and they sent a copy by certified mail. While Dr. Einhorn was away, and after she returned on August 21st, the defendants sent out a memo to staff saying, Dr. Einhorn resigned. You're to tell any patient that wants to make an appointment with Dr. Einhorn that Dr. Einhorn resigned and her last day will be on September 18th. You're to tell any patient that if they want further surgical or medical attention, they should contact Dr. Hatt. This is in Exhibit 5, which is attached to the verified complaint. Dr. Einhorn didn't get a copy of that memo. She had to ask for a copy of the memo from the administrative assistant at Osney. In addition to the memo, staff were being told, don't give any information to Dr. Einhorn. This is despite the fact, Your Honor, that Dr. Einhorn, by her own admission, continued to be a shareholder of the company through September 18th. If she asks for any information, tell her you can't give it to her. Tell her to see Dr. Hecht. Tell her to submit a request for the information to Dr. Hecht. If any patients call to schedule surgical or medical procedures, don't give it to Dr. Einhorn. Give it to one of the other doctors. None of this can be disputed because it's all set forth in the memorandum, which is attached to paragraph 5 of the verified complaint. And in fact, when Dr. Einhorn returned from her vacation on August 21st, and she confronted this whirlwind of activity to not only force her out of the business, but to exclude her from obtaining any information. What patients of mine did you contact? Why are you telling staff that I'm resigning? When Dr. Einhorn asked for information, they told her, no, you can't have it. These individual defendants even went so far as to take all of this information, all of the corporate books and records, the board meeting minutes, the shareholder meeting minutes. We know that there are at least some, because Dr. Einhorn has seen the minute binders before. Financial information as to the company, financial information as to the related entities. As we allege in our complaint, there are 2 related LLCs. They took all that information out of the administrator's office, and they locked it away somewhere. We don't know where. And they did it because they wanted to prevent Dr. Einhorn from obtaining any information as to what was happening at OSNI. So despite their August 7th letter, even if we take it at face value, where they say, we accept your resignation and your resignation's effective June 18th, despite the fact that she's still a shareholder there, they're going to prevent her from getting any information or doing anything. They even went so far, Judge Paris, as to say to the staff, don't talk to Dr. Einhorn. From that point forward, it was a Donnybrook at OSNI. Dr. Einhorn retained counsel. There were discussions between counsel. A formal request was made for documents. We still don't have all the documents. Board minutes of meetings to see what the board actually did at various times during the meetings. And all of these documents had now been taken by these individual defendants to do with what we don't know, because we don't know where they are. There's another aspect to this, Your Honor, which has severely impacted Dr. Einhorn. And that is Dr. Einhorn is a wrist and hand surgeon. When Dr. Einhorn schedules surgeries, or even before she schedules surgeries, these patients come into what they refer to as a funnel. And what that means is there are different stages of a patient's treatment. There's an initial visit for an analysis, a diagnosis. Then there may be some therapy. If the therapy is not successful, there may be some surgery. And if there is some surgery, then there's a regimen that has to be followed to follow up to make sure the surgery went well and that the patient is recovering well. A physician, such as Dr. Einhorn, has an ethical duty to make sure that her patients are cared for. She has an ethical duty if she's being told that she's going to be barred from OSNI after September 18th. It has an impact on what surgeries Dr. Einhorn can schedule, because she won't be there to do the follow-ups. And as I mentioned earlier, Dr. Einhorn is a hand and wrist specialist. That's the bulk of her practice. She has that, what's called a subspecialty. None of the other defendants at OSNI have that specialty. There are spine surgeons, there are shoulder surgeons. None of the other docs at OSNI are hand and wrist surgeons. They can't do it. Or perhaps they can do it, but it's not their specialty. When a patient comes to a specialist for that procedure, they come to Dr. Einhorn, not to the other doctors at that facility. So that created a problem that since her return from vacation on August 21st, she's been severely limited in what she could schedule, because it would be doing her patients a disservice to schedule surgery that these defendants are going to prevent her from following up on. There are other obligations Dr. Einhorn has that she can't follow through on because these defendants have barred her from OSNI.
Is she barred now?
Yes. Dr. Einhorn has acted as a treating, testifying witness in cases before the court. Dr. Einhorn had a deposition scheduled for Wednesday, September 18th, and she couldn't attend that deposition. She had to call counsel and say, we'll have to reschedule that deposition because I've been locked out of my practice. Dr. Einhorn has patients that she has developed and nurtured over time that specifically trust and rely on Dr. Einhorn, who have specifically contacted her and said, what am I going to do now if I can't see you? They're really concerned. So that's been a real problem. What this all culminated in after Dr. Einhorn was forced to retain counsel, after OSNI counsel got involved, after there were exchanges of demands for documents, and even, I might add, settlement discussions. What happened is that these individual defendants called a meeting of the shareholders of OSNI for September 16th, 2 days before the supposed resignation of Dr. Einhorn. They had this meeting at the end of the day. Dr. Einhorn was present. Now, when Dr. Einhorn comes to these meetings, and there were at least 2 or 3 of them between June 18th and September 16th, she's asked to record the meetings so there'll be a record of the meetings, which is important because the defendants don't have any minutes of the board of directors. She was denied every time. They don't want a written record of what happened at these meetings. So at the meeting, without any explanation or basis as to what or why they were acting in the way they were, they removed Dr. Einhorn from the board of directors of OSNI. Why did they do it? Because they're trying to freeze her out. Why did they do it? Because unbeknownst to Dr. Einhorn, immediately after this board meeting, we find out the next morning from counsel for OSNI. Immediately after they removed Dr. Einhorn from the board, these individual defendants held a reconstituted board meeting of OSNI, and all of a sudden they're terminating Dr. Einhorn for cause. Never before this meeting was there notice of a shareholders or board meeting that Dr. Einhorn got a copy of, setting up any meeting to consider a termination of Dr. Einhorn for cause. In fact, never before counsel got involved in this case, me, was there any discussion, was there any claim, was there any allegation that there was cause to terminate Dr. Einhorn's employment agreement? Never. It didn't happen until August 28, 2013, after I corresponded with plaintiff's counsel asking that they cease and desist from their conduct. That's the first time it happened. And since that time, there's been a cavalcade of, well, did you know that Dr. Einhorn has been breaching her fiduciary duties? We haven't seen any proof of this cavalcade, mind you. There's never been any formal notice to have this matter considered by the board, of which Dr. Einhorn's a member and can respond and defend herself. All there have been are accusations, some of them made and then later withdrawn when the defendants apparently realized that they're false. But some are still being pursued. What happened, Judge Paris, is that once the defendants realized that there was a problem here, that they're trying to kick Dr. Einhorn out of OSNI, saying that she resigned when she didn't, is they said, oh, we better come up with a plan B and we better do it quick. So they came up with plan B on August 28th, which was, let's start accusing her of doing all these nasty things, some of which, by the way, would have a very detrimental effect on Dr. Einhorn's career and her reputation. HIPAA violations, for example. All with no basis, but they're making those accusations. And they decided we have to come up with a plan B because we're going to have trouble saying that this is a resignation based on what she wrote in that June 18th letter. So while in their August 7th letter, Exhibit 4 to the verified complaint, they said your last day is September 18th, all of a sudden, after they dumped Dr. Einhorn from the board of directors, they meet secretly at night and they terminate her for cause. No hearing, no meeting to flesh out, no notice that these are the formal claims against you. The most they did was to send an email saying, we've heard this, tell us if it's true or if it's not true. We've heard this, tell us if it's true or if it's not true. During the time that we're trying to negotiate a resolution of the case, they're trying to force Dr. Einhorn to defend claims that they haven't even submitted any proof of. It's nonsense, and it's all a cover-up, and it all is illustrative of exactly what they were doing, and that is by hook or crook, we're going to get rid of this doctor. And that's what they did. I received an email from defendant's counsel on the morning of September 17th telling me that they had this meeting after Dr. Einhorn was kicked off the board, telling me that Dr. Einhorn is barred barred from walking into Osney's offices on that day, September 17th. Prior to that time, as I mentioned, their position was, oh, we accept your resignation, thank you very much, your last day is September 18th. They made several threats between August 7th and September 16th while they were sticking with their resignation story. And those threats were, you better not try and come on the property after September 18th. It will not be in your best interest. You better stick to the script and tell patients that you resign, otherwise it won't be in your best interest. You better not come here. They tried to intimidate this doctor to prevent her from practicing medicine. Dr. Einhorn, on my instructions, didn't try and challenge their bar on September 17th, and she has not been back on Osney's premises since September 17th. That's why on September 17th, we filed our verified complaint in this action. I asked counsel for Osney if counsel will accept service, and counsel said, I'll be out of town this week, so it wouldn't be best for me to do that. On September 18th, we filed our motion for TRO and preliminary injunction. I sent counsel a copy on September 18th of the TRO and preliminary injunction, as well as notice that we would be heard. Originally, we were set for yesterday, and Mr. Weiser sent counsel a notice saying it's going to be put off till today. That's why we're here right now. Your Honor, this has had a devastating impact on Dr. Einhorn because she has to sit at home. She can't practice medicine. She can't schedule patients. She can't even respond to patients because she's afraid she'll violate her restrictive covenant, or she's afraid that they will accuse her of violating her restrictive covenant. It's not as simple as saying, well, go ahead and practice, and if you prevail in your breach of contract case or in your tortious interference case, the restrictive covenant won't apply. It's a lot more risky than that because Exhibit 2, the restrictive covenant, contains a provision, and we're not admitting it's enforceable, I think it's a questionable provision, but it's a provision that says if you violate your non-compete, there are liquidated damages immediately assessed at $250,000. Dr. Einhorn has an established relationship with Munster Community Hospital and Emergency Room. She receives the bulk of her referrals from Munster Community Hospital. She can't do that anymore, and she's been asked, why can't we send you any more patients? In the absence of an injunction, Munster Community Hospital and ER is going to have to find somebody else to refer cases to. And these are going to be patients, and more alarming, this is going to be a practice which is never going to be able to be rectified through Dr. Einhorn's breach of contract case. The relationship will be gone. She will have to effectively go somewhere else for the next 2 years without an injunction and establish a new practice and start from scratch. Courts have allowed injunctive relief under those circumstances. Dr. Einhorn has a referral relationship with Comprehensive Care. It's an occupational health care clinic. Those are all gone now. If they can't contact Dr. Einhorn to take those referrals to treat their patients, she may never recover that practice. 2 years will go by. I don't know how long it'll take to try the case, but 2 years will go by under the restrictive covenant, and that practice will be gone. Dr. Einhorn will have to start from scratch, and it's pure speculation whether she'll be able to reestablish that practice. Dr. Einhorn, as I mentioned earlier, has patients who contact her and say, we want to continue with you, we trust you, we want to keep working with you. She has to tell those patients no, unless an injunction is issued. She has other physicians in the community that refer patients to Dr. Einhorn. She can't take those referrals, and she's going to lose those relationships and have to start from scratch in 2 years unless an injunction is issued. Your Honor, the first element of an injunction is that Dr. Einhorn's remedy at law are inadequate, and there will be irreparable harm if an injunction isn't granted. Those are examples of the type of irreparable harm Dr. Einhorn will encounter. Her reputation will be diminished, if not eliminated. She won't be able to continue these relationships. They will be destroyed. And she won't be able to serve those patients who want Dr. Einhorn to be their doctor in this community where she's worked for 13 years. She'll have to go somewhere else and start all over. Count one of the verified complaint is for breach of the employment agreement. The employment agreement has an arbitration provision in it. It's the only arbitration provision. The tortious interference counts against all of the defendants. There are 2 counts. Those counts are not subject to an arbitration agreement. Therefore, those counts are properly in court. We have set forth the law in our motion, which establishes that notwithstanding the arbitration provision in the employment agreement, this is an appropriate case for an injunction. Because without the injunction, any result or remedy that can be achieved in arbitration after whatever period of time it takes to get an award will be meaningless. Because by that time, Dr. Einhorn will have been prevented from practicing her medical practice. She'll have been prevented from accepting any referrals, seeing any patients, even talking to anybody because of the threat of that restrictive covenant, which defendants have made clear they are going to impose on her. And as the cases we cite to the court state, in this kind of situation, an injunction issued by a court of equity is not only not prohibited by an arbitration provision, but it's consistent with the principles of arbitration and the public policy in favor of arbitration, because it preserves for the parties a remedy so that when you get through the arbitration proceeding, there could be a remedy. Without an injunction, there will not be a remedy. In Indiana, there are cases that have recognized both in state and federal court that taking away the livelihood of a plaintiff by diminishing the goodwill that the plaintiff has established, by taking away the reputation of a plaintiff, and by causing an impact that's not readily calculable by damages, because this involves future relationships, it involves current relationships for future business. When you have a damage, an impact like that cannot be readily cured by damages, an injunction is appropriate. The second element for an injunction, Your Honor, is a reasonable likelihood of success on the merits. And I would point out that in an arbitration context such as this, where the breach of contract claim is involved, that is a very low standard. We cited to the court the local lodge number 1226 versus Panoramic case. It's a Seventh Circuit case, where the court recognized that in this case, where it's a matter of preserving a party's ability to get a remedy in arbitration, all a plaintiff must show is a sufficiently sound case that has an opportunity to be adjudicated during arbitration. And an injunction is proper to prevent the arbitration from being a futile endeavor. That's what would happen here without an injunction. We would be forced to arbitrate while we're litigating the tortious interference claims, and somewhere down the road, by the time we get a remedy, if we prevail, which we think we will, there'll be no remedy for Dr. Einhorn because she will be cut off from the physicians, from the hospital, from the comprehensive care center, and from all the other patients that she served for the last 13 years. It'll be too late for a remedy. And that's simply not right, and a court of equity can issue an injunction to prevent that from happening. We think that there is a reasonable likelihood of success on each of our claims because the June 18th letter clearly shows that there was no resignation. So the OSNI attempt to force a resignation is clearly a breach of that employment agreement. There's no basis to allege that Dr. Einhorn committed any acts that would constitute termination for cause. These are claims that were trumped up at the last minute in order to cover the defendant's tracks for a defective resignation claim. And therefore, we think those claims will fail too, and the attempt to terminate her for cause would be a breach of contract. We also believe that these same facts that I've outlined to Your Honor this morning are a basis for a tortious interference claim by these by these defendants. These defendants did not act in a manner that protects Osney. These defendants acted in a manner that's to Osney's detriment. These defendants acted in a manner to first violate Dr. Einhorn's employment agreement, second, to force Dr. Einhorn out of Osney, which immediately has the impact of denying Osney the benefit of an income stream, of a revenue stream from Dr. Einhorn's practice. The defendant's actions result in the other doctors at Osney having to absorb, which I suppose was part of their motivation, to absorb Dr. Einhorn's practice, her patients, her referrals. In practices where these defendants already have full practices of their own. So they're going to have to squeeze in the patients that you would otherwise have gone to Dr. Einhorn into their practice and try and serve patients who may need the subspecialty of hand and wrist surgery, which means either they're going to assign a doctor that doesn't have that subspecialty, or they're going to have to send that patient somewhere else. There is no way that these defendants can justify the actions that they took, and therefore their actions constitute tortious interference.
So you're requesting that, if I understand, you're requesting she be reinstated back till this is all...
Well, we have two primary requests and an alternative request. The two primary requests are, number one, that these defendants be enjoined from terminating Dr. Einhorn's employment agreement and that she be reinstated immediately. Number two, that these defendants be enjoined from interfering in any way with Dr. Einhorn's practice at Osney of her medical and surgical practice, that she be able to continue to see her patients. And that's the one that's important because, as I've outlined in general terms, they made life at Osney for Dr. Einhorn a living nightmare by not letting anybody talk to her, by not letting her have any information, and by doing everything they can to make sure she's not able to get patients scheduled to see her. So those are the two primary elements of relief that we seek, Your Honor. The alternative relief we seek is that this court enjoin these defendants from applying or in any way enforcing the restrictive covenant so that they can't interfere. If they're not going to allow her to practice at Osney, that they can't prevent her with risk of a purported liquidated damage clause of $250,000 and other damages. They can't prevent her from going somewhere else within the community, going back to Munster Community Hospital or to comprehensive care or wherever, and continuing her practice. So those are the three forms of relief that we ask from the court, the last one being in the alternative. Your Honor, we appear before you this morning on this TRO because despite our efforts to avoid this, we haven't been able to, and the defendants have locked Dr. Einhorn out in the most unethical and vicious way that they could. Dr. Einhorn needs to be able to practice her livelihood. She needs to be able to earn a living, and she shouldn't be forced to go somewhere completely foreign to the practice that she's had for 13 years to start from scratch. Thank you, Your Honor. For that and for all the other reasons that we set forth in our motion, we ask that a TRO be granted. And, Your Honor, one of the issues that we addressed in our motion is we asked the court to waive bond, or in the alternative, to set a bond in a minimal amount. And the reason we asked that under Rule 65 is because the purpose of the bond is to secure a party against whom a TRO is entered from any damages that may occur. Osney will not incur any damages if Dr. Einhorn is allowed to do what she's been doing for the last 13 years. In fact, they're going to make money from it. So there's no basis other than to try and make this as difficult as possible on Dr. Einhorn to impose a bond, or at least any bond of any significance. At worst, if a TRO is entered and later vacated, or if a preliminary injunction is entered and later vacated, at worst the defendants will have suffered costs, at worst. But they will suffer no damages, and they can point to no damages. So for those reasons, Your Honor, we respectfully request that the court grant our motion for a TRO. Thank you, Judge.
Counsel?
Thank you, Your Honor. And thank you for allowing me to argue, even though my prior motion has been granted yet.
Sure.
Thank you. Well, I hope to be brief, and I'm going to address the arguments that have been made by opposing counsel in the inverse. In other words, I'm going to deal with what he dealt with last first. I'm keeping this case really simple. This whole matter shouldn't be before the court. What opposing counsel made a very brief reference to, I know the court has read the pleading, so I'm not going to belabor the facts too much. But contained within the agreement, which I know the court has read, is a provision that says arbitration. It's very clear. It's not that long. It says, any controversy or claim arising out of or related to the breach, this agreement, or the breach thereof, shall be settled by an arbitration in accordance with the rules then obtaining of the AAA, and it goes on. It's very standard language. Based on the arbitration provision, it's very clear that this court does not have the subject matter jurisdiction to issue a preliminary injunction. In the pleadings that have been filed by the plaintiff, they concede this point. They concede the fact in the existence of the arbitration. They concede, though there's a slight nuanced change in their argument, but they concede that the disputed items with regards to whether there has been malfeasance on the part of the defendants is to be ruled on or determined by an arbitrator. The slight change that has occurred in their pleadings and their argument, Your Honor, is up until 15 minutes ago, they had not made an argument that the tortious interference claim somehow was independent from the breach of contract claim. That's nowhere in their brief. Let me address that very quickly so I can dispel that thought. It's very clear that the actions that they are submitting are a purported tortious interference are the actions which are identically the breach of contract. The termination, the locking out, the sending of a termination letter, the acceptance of a resignation letter, the manner in which the defendants have been acting is exactly the wrongful acts that they are claiming constitute a breach of contract. So to say that the tortious interference claim does not arise or relate to the agreement is incorrect. It's a misstatement of what the reality is. So let's deal with the arbitration and whether or not arbitration alone is sufficient for this court to not only deny the motion for the TRO and the injunction, but also to dismiss this case sua sponte, as the court has the ability to do. The law that the plaintiffs cite to support their theory that this court has the jurisdiction to issue a preliminary injunction is of no precedential effect to this court. And again, this is something that the plaintiffs very quickly brushed through in their oral argument this morning. They cite to a handful of federal court cases where the courts have said in those distinct situations that they were going to grant or deny injunctive relief. That flies in the face. And mind you, they cite to no cases in Indiana, trial, appellate, Supreme Court, that affirm or validate or in any way incorporate this doctrine into this state's jurisprudence, those concepts. Further, they ignore the wide body of case law in this court and in this state that regularly enforces arbitration to the detriment of those seeking injunctions. One of the critical cases that this court is most likely aware of is the Goebel versus Blocks and Marbles cases. All of these cases, and then there's AAA versus North Miami Community Schools, all of these cases stand for the proposition that while the court has the jurisdiction and the authority to determine disputed issues with regards to an arbitration provision, if there's an argument about whether or not it applies, or whether or not this issue is arbitrable or that issue is not arbitrable, while the court does retain that jurisdiction, the case law is clear, and I don't want to belabor and cite to it to the court, that anything post-contract formation, i.e. what the defendants may or may not have done right, i.e. plaintiff's request, e.g. plaintiff's request to try to get injunctive relief, those are all within the purview of the arbitrator. Further, AAA, which is what we are bound by, has its own injunctive relief rules that the plaintiff could avail herself of if she wanted to. So, from a simply jurisdictional basis alone, this court could deny the motion and dismiss the case.
Well, how does the arbitration clause reconcile with the covenant not to compete?
Well, it's a fair question, Your Honor. I would stipulate that, or I would submit that we could, as the defendants, we could get relief to enforce the covenant not to compete from AAA. We also have not made any actions, we have not filed any claims to enforce the non-compete within this court. So, and also, the covenant not to compete enforcement section is a provision that inures to the benefit of the employer, not to the employee. But that's putting the cart before the horse. We are not stipulating that this court is the jurisdiction for anything at this point. We are just saying that as it relates to their claim, at this point, the claims that they're bringing, claim for an injunctive, they are barred. But your question is a good one, and should we get to that point? Should we try to enforce a non-compete in this court after having argued that this court does not have the jurisdiction to compel us to do or not do something? That might be a defense that the plaintiffs might bring back towards us. But we're just not going to pin ourselves down at this point on that. But we do say that we do have rights in the AAA to get non-compete. If she wants to violate the non-compete, she can do it. It'll be up to us to go to either the arbitrator or the court if we choose to decide to enforce or not enforce. If she chooses to and we go to arbitration, she should be ready that if the arbitrator issues an award that the non-compete has been breached and issues an award that she is bound by the non-compete for 2 more years, will then come to this court with the arbitrator's award, domesticate that award, and then enforce it against her. I mean, there's all sorts of permutations that occur. But it's a fair question from the court. But I will not stipulate what
position does that put her in where, I mean, we don't have an arbitration. She doesn't know whether the covenant not to compete is going to be enforced. I mean, if you already had an arbitration, you came here and the arbitrator made some finding.
Sure. Well, Your Honor, where is she left at? This is a breach of contract case. We'll all agree that at its heart, this is a breach of contract case. This is a breach of contract with regards to employment. She's been fired. She quit. She is a aggrieved former employee, apparently.
Wasn't that an issue for the arbitrator, whether she quit or not?
Absolutely. The arbitrator can decide whether she quit. That's not for this court to decide. That's precisely why the law is that the arbitrator...
Why aren't we having an arbitration?
I agree.
And preserve the status quo, have the arbitration, and what the arbitrator decides should be
Your Honor,
you live by.
The status quo is she's terminated. That's the status quo. She's resigned and she's been terminated. And let me address the issue of that very point. Opposing counsel made the argument that he said it repeatedly that the letter was not a resignation. That's over. The letter was issued June 18th. There was a June 19th board meeting, which opposing counsel skipped in his recitation of the facts today. At the July 19th board meeting, she came back to the defendants and said, "Will you accept my resignation?" At that point, she advised all of them that she had resigned. On August 7th, as opposing counsel mentioned, the letter was issued by defendants saying, "We accept your resignation." And then...
Aren't these factual issues?
They're factual issues, but it goes to the issue of likelihood of success on the merits. If the court is even going to entertain this concept of an injunction, which I don't believe the court should because the arbitration provision is clear, and the Indiana case law is clear that the court does not have the authority to issue a injunction. But if the court is going to go there, then yes, it is a question of fact, and the question becomes, is there a likelihood of success on the merit? Not a small probability of success, not a chance of success, but a likelihood of success on the merit. And on that point, Your Honor, what plaintiffs ignore is plaintiffs' own actions, plaintiffs' own words. Plaintiff issuing an email dated August 8th, the day after she received our resignation letter, accepting resignation, which she references her last day. An email dated
the same day, August 8th, saying, no new patients for me. No new surgery should be scheduled for me. Surgery scheduled for the week after August 19th will be transitioned to other surgeons. We need a transition plan for my patient she's referring to. All of that is ignored by plaintiff in its recitation of the facts. All of these are documents that they have, none of which they attach to their briefs, none of the facts of which they provided to the court. We have the plaintiff herself, after she resigned, clearing out her draw account. Very, very unusual. These physicians have these accounts which they take their draws on. She emptied it to zero. Emptied it. Even though it put her technically in the red in terms of future obligations she'll have as a shareholder. She did that. She left. She cleared out everything. And they say, not a resignation. Not a resignation. Okay. Well, we have just as many facts as they have, at a minimum, which would demonstrate there's no likelihood of success on the merits of the claims. Thereafter, while we're doing our investigation, we learn more about Dr. Einhorn. Dr. Einhorn is charging personal bills to a credit card, company credit card that belongs to another employee. $8,400 worth of bills. We have the bills. We have statements from our own employees attesting to these issues. She's charging for dog grooming. She's charging Amazon. She's charging, I don't know if she drives an Audi, but there's an Audi bill. I mean, all of these, $8,400, she's doing that. In her own patient charts, she's referring patients to outside practices, not at home. We submit and surmise this is where she wanted to go work after she resigned working from us. We just learned last night that she charged, $9,000 worth of Apple equipment, Apple products, iPads and so forth, personal stuff for herself on company time. We use all of these and other issues as a basis for a termination, which we were within our rights to do, to fire her. We have those rights under the terms of the employment agreement that everyone is bound by. And what I find interesting is that of the case law and the arguments that plaintiffs are making and citing to, they don't cite to a single case within the state of Indiana, federal court, any other neighboring states in which a terminated plaintiff causes the defendant employer to rehire. Not one single case. It is the functional equivalent, Your Honor, of reverse indentured servitude for us to rehire an employee who resigned or that we fired. However they want to take it. We take both positions. She did resign, and for good measure, we terminated her for cause. And we were fully within our rights to do that. If the plaintiff believes that we have somehow done something wrong, we're willing to stand up to those claims in an arbitration and defend ourselves. And if she proves her case, it's a damages case, just like any wrongful termination cases. If Dr. Einhorn is, I'm sure, a fantastic doctor. I'm sure she's a great person. But I'm also sure she's not the first physician with an employment contract, with a non-compete, with an arbitration provision to be fired within the state of Indiana. I am certain that that is not the first time that has happened. However, there isn't a single case that the plaintiffs have cited to demonstrate that this court or any court in the state of Indiana will cause the employer to rehire her. I am sure that Dr. Einhorn's patients, some of them will miss her, and I'm sure it has caused her some measure of inconvenience. But those are proofs that she will make in an arbitration when she tries to demonstrate to the arbitrator, I've been wrongfully terminated. I didn't get salary for 2 years. I was taken out of the stream of the industry. I've lost my patients. I was forced to up and move 15 miles away to a new location. I had all those startup costs. I'll bring in an expert who will testify about the diminution in my salary. She's going to make all those claims. This damages case. Doctors, they all think that they're the most unique. My parents are both physicians. They all think that they're the most unique, best doctors, and no one else can do what they do. However, there's no law out there that says that doctors are a unique profession. Hand subspecialists are a unique profession, and therefore the court, where there's evidence of a termination, from our perspective, a rightful termination, a court is going to reinsert that employee back to work with the employer again. There's just no cases that say that. Now, in terms of evidence, as the court identified, there are factual questions here. I think that the legal question is squarely on the side of the defendants, and that is the issue of the arbitration provision. Square, the court can rule on it, and frankly, oral argument should be resigned to legal arguments. But there's been proffer of factual evidence. At a minimum, we've established no likelihood of success on the merits, which is a prong. At a minimum, irreparable harm. This is a breach of contract case. Her damages are income. If she goes to another location, she can go start up a business, and if she demonstrates that her income in 2013 and 14 is 50% of what it was in 2012 in the first part of 13, and she simultaneously proves to the arbitrator that our termination was wrongful, she'll get an award of damages. That's her case. She, in her own complaint that she attached to her verified complaint, attached to her brief for summary for injunction, she asks for damages. There's no question. And the irreparable harm that opposing counsel cites to is again this more amorphous, legally unsupported. I'm the only physician within 15 miles who can do this, and therefore I can't see anybody, and this is irreparable harm, and I'm going to do a detriment to the community at large. I don't see any evidence of that. This is just a physician who's been terminated, who's done bad things that we have discovered, and she also resigned. So if you look at the prongs, if we get over the legal argument and we look at the prongs for today, or if the court is inclined, we're going to have an evidentiary hearing, and the court considers these prongs, no likelihood of success on the merits. I mean, it can't be probability of success. It's got to be likelihood of success. No irreparable harm. Balancing the harms, Your Honor, what the court would be what the plaintiff is asking the court to do is asking the court to reinsert into an environment where she's already been fired an employee. Dr. Einhorn is still a shareholder. Dr. Einhorn is still a member. And if she has rights, she can abide by those rights and she can have the benefit of those rights. Mind you, the complaint, nowhere does it say anything about shareholder oppression. I mean, I heard plaintiff's counsel argue about all these bad things that have been done while, by the way, the plaintiff was the managing partner of the company. All these bad things about the finances and the books and the records. There's no shareholder oppression claim in there. But she has shareholder rights, she has member rights, we have not dispossessed her of it. So, you have on one hand the fact that she has all of her remedies to get an arbitrator, B, an injunction. Go to AAA and get an injunction. Go down that route. AAA has those opportunities. Or go to AAA and get damages award. But alternatively, the court would be asked to bring her back, even after we fired her for malfeasance, for taking, for using company credit cards for personal bills, not borrowing, using, taking the card unbeknownst to the person whose card it was. And then finally, public policy. There's no public policy aspect, except there's clear case law in all jurisdictions, including Indiana, about the courts, there being a policy for the courts to interpret and enforce its own contracts. And the contracts within the state. And here, the contract says arbitrate. I have with me, Your Honor, documentary evidence to support our position regarding the rightfulness of our termination, which I could present to the court, I could present to plaintiff. Plaintiff and plaintiff's counsel have been aware of these things, about these issues, about why we fired her for cause. At first, plaintiff's counsel said, they never brought any of this to our attention. And then about 5 minutes later, he said, well, they sent us an email about it, and they expected us to respond, but we couldn't because we were so busy. So we have not received any response to any of these issues. It's been silence, no explanations, no affidavits, no nothing. So I could present that to the court if the court would entertain it and wanted to see it, because it would move the court one way or the other on the likelihood of success, on the merits. So I would ask do you have any interest in seeing that? I don't want to belabor points the court may address at a later date or does not need to see.
Your Honor, I don't want to get into my reply now, but I think they should present that evidence, and I think we should have a preliminary injunction hearing as soon as possible so that they will agree to let me put Dr. Einhorn on the witness stand. They can cross-examine her, and I can cross-examine their witnesses.
I think if you're going to be giving me evidence, counsel should be subject to cross-examination.
Okay, then probably the more appropriate time would be, is the court saying that the court is going to entertain a preliminary injunction? Because, again, I think the court at this point will take the position that the arbitration provision on its face does not allow for an injunction to be issued. Moreover, the case law, and I would be really interested in hearing your reply.
I mean, if we had an arbitration and with this covenant not to compete out there and no arbitration having been done, it troubles me that she forced to sit at home.
Well, the point is, though, Your Honor, that if the court has reviewed the covenant not to compete, it doesn't force her to sit at home at all.
Well, it allows her to, she can practice, but with the fear of being sued.
No, not even, Your Honor. She can practice beyond 15-mile radius. And the covenant is not that.
Your Honor, would you like me to reply? Or?
Well, I'm trying to understand here this arbitration provision. We're here, we didn't arbitrate, now we're here.
And I don't want to interrupt counsel's argument, but he's asking Your Honor to make a ruling now, and I'd like an opportunity to reply before that.
Yeah.
Right. So I guess, yes, I'm definitely asking the court to make a ruling. The ruling that I'm asking of the court is, and while I understand that the court perceives that Dr. Einhorn is somehow going to be prevented from practicing within 15 miles, that's not illegal. There's not unlawful. It's not unlawful for us to have a contract provision. This is a provision that Dr. Einhorn agreed to. Every physician that the practice has an identical term in their agreement.
I know, I've seen them before.
Sure.
I have another case almost just like this pending right now.
And I don't, and be it an arbitration gets filed tomorrow, be it an arbitration or be it within this court, the court would not, there are no cases that they've said where courts have granted and have had upheld injunctions in those situations. And arbitration could probably be even faster than the adjudication of a decision before Your Honor, if the court did even have the jurisdiction to hear the case, which it does not. So even, I mean, it's a breach of contract case. Let's say she wasn't a physician. Is every person who's entitled, who is subject to a covenant to not to compete in every industry, be it a physician, a dentist, a salesperson, now going to have the ability to come to court and get an injunction? Don't fire me. I see the writing on the wall. You've already fired me. I'm going to go file a lawsuit the next day. Don't fire me. I want to get an injunction because you're going to inhibit my ability to practice and make money. There's no case that supports that. They have to demonstrate some other kind of irreparable harm. And in this case, it's a damages case. She makes a living. She earns money. She's successful and has successfully earned a lot of money. If by some chance she wins ultimately, her proofs are going to be to demonstrate that there are damages. Court probably remembers Bobby Leonard. In the Bobby Leonard case, the Supreme Court said, this is after he'd gotten fired, the Supreme Court said, except in rare cases, a preliminary mandatory injunction should not be issued where it would have the effect of granting to the complainant all the relief that she could obtain upon a final hearing. The relief that the plaintiff is looking for is put me back at my job, have me earn my money, and continue doing what I'm doing as if that employment agreement did not exist. In the Bobby Leonard case, the court, and there are other courts just that say the exact same thing, that if you were to grant the injunctive relief that they're asking for, you would be putting her in the place of winning the case. We would be forced to rehire her. We would be forced to put her back in front of patients. We would be forced to have to continue to pay her. Even though we believe and have evidence that she has done malfeasance, even though she resigned and advised witness after witness after witness and put in document after document after document, I've quit. I don't want to see any more patients. I'm done. Given those circumstances, an injunction either now or after preliminary and evidentiary hearing would be inappropriate. I think what the court is saying is that I acknowledge, or the court acknowledges, that there's an arbitration provision. That's undisputed. And the court is concerned that if an injunction is not granted, that the plaintiff somehow is going to be harmed. And it's possible. But the harm that the plaintiff will have is not irreparable, Judge. It will be a damages. And I would challenge the plaintiff to find me a case where this court in Indiana has granted an injunction in a situation like this. I'll reserve for a brief rebuttal.
Are we having replies and rebuttals, Judge? Is this going to go on?
Well, I was a little slower than you were, but not quite.
Let's see where it goes here.
Your Honor, the AAA won't hear this case on an emergency basis. In order to have an arbitration conducted on an emergency basis, the contract for arbitration has to contain a provision requiring emergency relief. This contract does not. So this case would languish in arbitration. Even if it languished for 60 days, the time that the defendants would have to respond, the damage would be done. There is no relief in arbitration. If we go to arbitration, by the time we get there, it's over. We have cited to the court case law, which clearly supports, unanimously supports, the issuance of an injunction by a court of law in aid of arbitration. They have not presented to Your Honor a single case that said, no, you can't do that. I can see there's not a case in Indiana in the appellate court or the Supreme Court. There are cases in the trial court, and I looked through my notes to find it. I don't have it with me right now. But there is a case in the trial court where the court recognized the issuance of an injunction in aid of arbitration is appropriate and went through the analysis, found that in that case there was an adequate remedy law and therefore it denied it, but clearly recognized that there can be an injunction. It's appropriate to issue an injunction in aid of arbitration so that the party in the arbitration can have a remedy. And I can submit that case to Your Honor and to counsel. I went through my notes and I don't have it with me. But it's a trial court case. It's not a case that I could cite in my brief. Every court that I found that's considered the issue has recognized the principle that an injunction can be issued in aid of arbitration. The concept that we can just run into the AAA and get an arbitration award on an emergency basis is made up. You can't do it. The AAA will not hear a case on an emergency basis unless that's what the parties agree to in the contract. So this plaintiff will have no relief if there's no injunction. Now, we started out this hearing on a very interesting note, and that is I asked whether we can present evidence or whether we're going to do argument. The defendants didn't want to get into any evidence. I sent them by email a copy of the emergency motion last Wednesday. Today is Tuesday, and the defendants never filed any evidence. They didn't file a verified answer. They didn't file a verified response to the motion. Zero. Instead, the defendant stands before you today and says, oh, we can give you this litany of all these terrible things that Dr. Einhorn did. It's all bogus. The claim that Dr. Einhorn stole a credit card from the administrator's office is a lie. And until the defendants are willing to go on record and respond to a verified pleading with a verified pleading, this court should not entertain unsubstantiated claims. Let them go on record and make a verified statement. They won't do it because it's a lie. The claim that Dr. Einhorn used a credit card to pay for grooming for her dog is a lie. It's so outrageous it's not even funny. Let them file a verified pleading and go on record. The most deceptive thing these defendants have done this morning is tell Your Honor, oh, we have document after document. We have them. Gistinson didn't show them to the court or attach them to his pleading saying, where Dr. Einhorn supposedly says, I resign, I'm terminated, I quit, I'm leaving. That's a lie. It never happened. The documents the defendants are referring to, which conveniently, in the last several days, they didn't put before the court in a verified pleading, and they're avoiding evidence. God forbid that anybody testifies and be cross-examined today. What they're talking about is that this doctor has a professional duty to her patients not to schedule surgeries that she can't finish. This doctor has an obligation to say to these defendants who are imposing this resignation, this bar, this lockout on her, she has a duty to say, we have to do something so these patients are protected. We have to have a plan. You can't just terminate me and leave the patient standing out there with nothing to do. Until we resolve this, during our settlement discussions, mind you, until we resolve this, let's tell people that I'm going to go on leave. Let's have a plan where they can have a doctor who you will allow to follow up with them. Dr. Einhorn was reacting to their bad conduct, and they're saying that those documents represent that she admits that she resigned and she quit. Let them file a verified pleading. Let them put a witness under oath on the stand to say that, and we'll respond to that because those claims are false. What this court, we submit, should do, because an injunction is appropriate in aid of arbitration, putting aside the tortious interference claim for a minute, it is appropriate to issue an injunction. What this court should do, Judge, to satisfy these defendants is schedule a preliminary injunction hearing as soon as possible. Let us put on our evidence. Let them put on their evidence. They can cross-examine our witnesses, we'll cross-examine their witnesses, and Your Honor will have something more than someone standing before you saying all these things happened without any verified pleadings, without any documentation before you, without any cross-examination. It means absolutely nothing until they do that. Let us do that. The law allows it. There's no case that says this court can't issue an injunction under these circumstances, and we should go forward with that. Your Honor, there's a case called Barlow v. Spies at 744 Northeast 2nd at 1, where the court did find, in that case, where a defendant who committed tortious interference and defamation by telling insureds not to obtain repairs from a body shop owned by the plaintiff, an injunction was appropriate. The court held that the plaintiff had no adequate remedy at law. The court recognized that a party need not point to a specific loss in its business in order to obtain injunctive relief. A witness testified that they had no idea the number of customers they lost as a result of the defendant's tortious conduct. The dollar amount can't be placed on the economic injury. In order to have a complete remedy, the Indiana court held that an injunction is necessary. Case after case in Indiana and outside of Illinois have recognized the appropriateness of an injunction where there's not an adequate remedy at law. And to say that Dr. Einhorn, it would be wonderful if the defendant stipulated to this, but to say that Dr. Einhorn in the arbitration, that they'll stipulate that she can recover damages based on her track record, all the lost business she's had, based on her last however many years of business, it'd be wonderful if they would stipulate to that, but you can be sure they're not going to argue that once we get to an arbitration hearing or once we get to a damage hearing in this case. They're going to say it's too speculative. They're going to say, how do you know what patient Munster Community Hospital was going to refer? How do you know what patient's comprehensive care was going to refer? It's not readily calculable. We can't do that, and that's the reason an injunction is necessary. And moreover, it's not a matter of just losing patients from June or from September of 2013 until September of 2015. This isn't a light bulb business. It's not something where you can go to another state and sell light bulbs there. This is a personal business. It's a physician-client relationship that's involved. They are relationships that have developed over the last 13 years with specific hospitals, with specific clinical centers, with specific other physicians. You can't just turn that off in Munster and say, go 15 miles away and turn it on over there. It's not a light bulb company. It doesn't work that way.
Let me ask quick, hypothetically, if it weren't for this covenant not to compete, would she have left?
I'm sorry?
If it weren't for the covenant not, is that what the major problem is here, the covenant not to compete, in the arbitration?
That's one of the major problems, but no, there are other issues as well.
Are you asking both of us, Your Honor, or just
Both
plaintiff?
of you, how you perceive it to be, the covenant not to compete? I mean, if this covenant not to compete didn't exist,
I would only point out that the plaintiff, or the defendants rather, had another option, which they didn't proceed with. First, they started with saying, oh, by the way, you resigned. And then they said, well, that won't work, so we're terminating you for cause. What the defendant had a right to do, it's in Exhibit 1 to our verified complaint, paragraph 5, is to terminate Dr. Einhorn without cause. They could do that on 90 days' notice without cause.
and then the covenant,
And then the contract says then that the covenant not to compete would not apply. They chose to do it this way because they not only want to kick her out of OSNI, they want to prevent her from practicing in this area.
In answer to your question, Your Honor, the covenant not to compete isn't the most important thing. The most important thing is keeping Dr. Einhorn out of our walls. That's the most important thing from the defendant's perspective. And the reason why I know that that's true is, though it is not, this isn't a presentation of evidence, and I know the court will take it for what it is, but in the context of the parties' discussions between counsel of the plaintiff and my colleague, in trying to settle the dispute, Dr. Einhorn was not happy about the fact that even though she resigned, she wasn't getting paid. One of the things that we offered in the context of those settlement discussions was we don't have to enforce the non-compete. That was a settlement proposal that was made. That's demonstrative of the fact that it's not the most important thing. The most important thing for us is keeping Dr. Einhorn out and enforcing the contract the way it is written. And if I may, while plaintiff's counsel was speaking with his client, I take it very seriously when, and I'm sure this wasn't meant as a personal attack, but I take it very seriously when plaintiff's counsel argues that the arguments that I'm making are lies. It's very important for
I was
the court.
addressing the facts, Your Honor, not the argument.
Yeah, and my reference to the facts as they are, as being a lie. I don't think that's very professional, and if the court would like, I can very clearly pull out the bill in which it refers to the dog grooming, the trips to Target, Lowe's, Shoe Carnival, Body Connect T-Mobile, the Olive Garden, Joanne, I presume it's Joanne Fabrics. I mean, again, these are issues that we can get into if the court finds it. Yeah, I know. And we also have sworn statements of witnesses. But, setting all that aside, Your Honor, while plaintiff's counsel did reference one case, I find it very troubling that they're asking this court for an aggressive form of relief. An injunction is not a motion to compel. It is not a motion to spec. This is an injunction requiring us to bring a terminated employee back within our walls. And the only thing that they have to rely on in terms of support, legal support for this, is a random case. I didn't hear what the citation for it was. And again, there are no cases anywhere that the plaintiffs can cite to where in this set of facts, not talking about the loss of an entire business, this set of facts, an employee has been terminated, and have the employee come back and compel the defendant to rehire the plaintiff. There's just nothing there. And if we're going to cite cases, I can cite to the case law. One of the cases that plaintiff cites to in their brief, for example, is the Roche case, R-O-C-H-E. They cite to that case in support of the proposition that the court can enter a preliminary injunction. However, one of the things that they failed to argue or failed to bring to the court's attention in their brief, for example, is that the contract between the parties in the Roche case specifically enumerated the right to seek an injunction pending arbitration. Now, the case that plaintiff cites to now, out of whatever he was reading, I'm not sure what the facts of that case are. But when he cited the case law in his brief, it was citing to a case where it said the contract provides for arbitration of disputes about the right of first refusal, but allows either party to ask a judge for equitable relief when arbitration is ongoing. That's not happening in this case. There is no such right in this case.
I don't know what the case he just cites you says. What I do know is that this case was totally distinguishable from the case that's before the court today. The case before the court today has an arbitration provision. It's clear. And if the provisions with regards to AAA and whether they'll enforce emergency measures are what plaintiff's counsel says they are, that's probably true, in fact. But it does not prohibit an arbitrator from granting injunctive relief, which is what they're asking for. So that's something for the court to consider. One other thing that plaintiff's counsel continues to say, these are Dr. Einhorn's patients, these are Dr. Einhorn's patients, her patients. That's not true. These are patients of the practice. In their employment agreement, Dr. Einhorn specifically acknowledged that all the patient charts belong to the practice. These are not her patients. She does not have a possessory right over them. She cannot come to the court and say that each one of these patients does not have the right to choose where they're going to get their medicine from. And that therefore she is somehow unique from any other physician or the physicians in her own practice who have covered for her for years, and that she's the only person who can provide these people with the health care that they need. Thank you.
I'm not sure if that was a rebuttal, Your Honor, but can I finish my reply? Your Honor, if the court refers to the employment agreement, paragraph 4, contrary to the argument that this isn't Dr. Einhorn's patient, first of all, there's a physician-patient relationship that's established here. It is her patient. And in paragraph 4, it makes clear that the employee, which is the shareholder, in this case Dr. Einhorn, shall have complete control over the diagnosis and treatment of patients assigned to him, and once a patient has been assigned to him, neither the board of directors nor any other employee of the corporation shall exercise any direct supervision or control over the individual treatment of the patient, except as may be specifically provided to the contrary herein. It is this doctor's patient once the patient establishes a relationship with this doctor. As best I heard it, the defendants have referred to one of the several cases we cited which clearly established the principle in the Northern District of Indiana, in the 7th Circuit of Illinois. No appellate or Supreme Indiana State Court case, either way, that I found, but the cases that do exist clearly establish the principle of granting an injunction in aid of arbitration. And it makes sense. How else is this doctor going to have a remedy once we get through an arbitration proceeding? Now, I think I heard the defendants concede that there are no emergency rules that can be adopted or taken advantage of here, but anyway, one day an injunction can be issued by an arbitrator. Either way, we still have to go through an arbitration. With respect to the plaintiff's or the defendant's prior response, the one before last, the complaint clearly does allege that these defendants acted in bad faith and breached their fiduciary duties to Dr. Einhorn as a shareholder. The defendants argued that we don't make that claim in our motion. Our complaint, which is adopted and incorporated into the motion, clearly states that they did. Tortious interference with contract is separate and distinct from breach of contract. While it relates to the employment, it doesn't arise out of the employment. It relates to the defendants behaving badly with respect to convincing OSNI to terminate Dr. Einhorn and to affect her relationships with her current and her prospective patients. There are 2 tortious interference counts. Only one of them named OSNI as a defendant. The other one relates to just the individual defendants. That's entirely separate and distinct from the breach of contract claim. Those parties do not have an arbitration agreement, and it's not subject to arbitration. As we clearly point out in the very first paragraph of our verified complaint, we specifically say that. Your Honor, I won't repeat everything I said about the state of the evidence. Again, in the second response, the defendants argued that they have this evidence or that evidence. They read off a list of bills, which I'm anxious to see, but they haven't provided any evidence. They had since last Wednesday to respond to our motion if they wanted to submit evidence under oath, under verification. I suggested this morning whether we put witnesses on and have evidence. The defendants declined. if we're going to have evidence, or if they're going to make claims, they can only do it if they put on evidence that's verified, because only then are they subject to the requirements of verifying their allegations and suffering the consequences when they raise factual allegations that are simply not true. And the ones that they've raised are simply not true. We should have a preliminary injunction hearing to find out. I thought it ironic, in response to Your Honor's questions, about, well, what about the non-compete? Can't the employer go in and come into court, not go to arbitration, and try and get an injunction to prevent Dr. Einhorn from violating the non-compete? And as best I could understand the argument by the defendants, the argument is, well, maybe we can, maybe we can't, we're not going to take that position now. But they acknowledge that clearly under the law, if they feel that the non-compete is being violated, they can come in and seek emergency injunctive relief. They want to have it both ways. They want to have that opportunity, but they want to prevent Dr. Einhorn from having that opportunity. And this concept that there's some huge harm if Dr. Einhorn, I think the way it was put is if she's in the walls of OSNI. We haven't heard what that harm is. There's been no evidence presented. There hasn't even been an explanation presented. Dr. Einhorn practiced medicine at OSNI up until last Monday, a week ago yesterday. And there was no harm from that. She saw patients. She earned money. OSNI doesn't just pay her money out of the goodness of its heart. She earns the money. The physicians are compensated based on what they do, not based on what anybody else does. So this concept that they don't want Dr. Einhorn in the walls of OSNI, not only is it unsupported, it doesn't make any sense. There's no harm. There's nothing to balance against the damage that's being done to Dr. Einhorn by not letting her practice medicine. And the status quo is not that Dr. Einhorn isn't working at OSNI. That's not what the law says. The law says the status quo is the last peaceable state of things between the parties. The last peaceable state of things between the parties is that Dr. Einhorn was a physician at OSNI and able to see and schedule her patients and provide the medical services that they need. Your Honor, the last thing I'll say is the bulk of the arguments that I've been asked to respond to, or that I have to respond to, are arguments based on law that's not been presented to the court, facts that have not been presented to the court through any documents or through any witnesses. It's all pure speculation and nothing to support it. We've submitted a verified complaint. We're prepared to present testimony, and based on all of the facts set forth in that verified complaint, as incorporated into our motion, we request that the court enter a TRO as prayed for in the motion. Thank you.
All right. So are we intending to arbitrate this case no matter what I do here? Is that what we're intending to do?
Your Honor, our preference would be to be in court, but the defendants can force us to arbitrate the breach of contract claim. The defendants cannot force us to arbitrate the tortious interference claim.
With all due respect, I'm sure the court took what appointed counsel with a grain of salt as to what we can and cannot enforce in arbitration.
All right. Well, the troubling thing is the arbitration clause to me and the covenant not to compete. I mean, it would seem like if there was an actual dispute as to whether she resigned or whether she's being terminated, that's something that should be arbitrated. But in the meantime, she shouldn't be denied her opportunity to pursue her profession while all that's pending. So I'm inclined to grant the relief and take it to arbitration, or I'll set it for a hearing on the preliminary injunction.
I'm sorry. Go ahead, you spoke first.
Your Honor, what we would submit to the court is a TRO is obviously temporary in nature. I think that we should be required to go the next step of the preliminary injunction, and then that preliminary injunction under the rules would have force and effect long enough to allow the parties to determine, I'll say determine, how to proceed. And the reason I say determine is because our position is we proceed before this court on the tortious interference claims at least. And I would like to proceed on the declaratory judgment on the breach of contract claim too, but they can force me to go to arbitration on that. They cannot force the plaintiff to go to arbitration on the tortious interference. So that's the position we submit to the court. Whether the parties can work something out in that regard by agreement is yet to be seen.
Just to understand where the court is going, they filed a motion for a temporary restraining order, not a preliminary injunction. Defendants have not had a chance to write a brief in response, and it sounds like the court's concern is that the plaintiff will be restrained through the covenant not to compete. So we'd like to understand that the nature of the court's ruling today is that, or would be, that the plaintiff, in terms of the non-compete, which is what the court is determining, is pointing to, that the terms of the non-compete will not be enforced against the plaintiff while an arbitration is pending. Because plaintiff's wherefore clause, if you will, seeks three forms of relief. Really, it's two forms. One is let her come back, and two is don't enforce the non-compete, which is their, I think as plaintiff's counsel said, it was sort of their fallback argument. So is it my understanding that as it relates to a TRO today, that the court is granting the TRO vis-a-vis not allowing us to enforce the non-compete while an arbitration is pending?
Well, is that counsel? I mean, is it imperative that we put her back with orthopedic specialists?
As a practical matter, if the defendant's conduct continues, we expect that there may be more issues that arise. And I'm trying to be as non-confrontational about this as I can and just address this as a practical matter. That's why we included the alternative relief. If the defendants are going to, and it's not a fallback position, it's an alternative relief, we seek both. Our preference is to go back to OSNI. But if there can be an agreement achieved where no party's waiving any of their rights, then perhaps under those circumstances, if the terms of the restrictive covenant are put in abeyance so that she's neither prevented from competing, as that term is used, and she's not subject to a $250,000 liquidated damage provision until a court or an arbitrator can rule on those, I think we can reach an agreement to that effect. But it would require an agreement, and it would be without prejudice to our other claims. And very quickly, Your Honor, the first thing that the defendant said a moment ago was asking about whether they haven't had a chance to file a brief and so forth. That's what the preliminary injunction hearing would be for.
Okay, so
that essentially that would be my ruling, that you hold the covenant not to compete in abeyance pending final resolution of all claims.
Okay, so as I understand it, procedurally, I think it's pretty similar to how we practice in Michigan, that the court, given what is presented to the court would issue a temporary restraining order that would state that what we just said, that the covenant not to compete is held in abeyance pending a resolution.
Either by, the issue is I don't know whether you're going to arbitrate this or whether you want me to hear the rest of it.
And so, in my understanding with regards to Indiana court rules as well, is that the temporary restraining order would be in force for 10 days.
10 days,
and then an additional
10
10 days potentially. which I
Until we
believe,
have a hearing.
We have a hearing.
which I believe would be a sufficient amount of time for us to file a responsive brief and set a date for the hearing within that 20-day period. And that,
Agreed.
so, I'm not stipulating to the relief, Your Honor, but it appears that
That's my rule.
that's what the court's ruling is. So, you'd like us to enter an order on a...
Yes, if you could both prepare an order.
And so we're on the same
consistent
page.
with
The
what
order would say that the motion for temporary restraining order is granted in part and denied in part.
Right.
It is granted insofar as the covenant not to compete is held in abeyance until a hearing that is set on the preliminary injunction motion, at which time the court will take testimony and so forth.
Your Honor, I object to the language that it's denied in part. It's being granted. The relief that we asked for is being issued.
Other than-
Your Honor asked a practical question, and I'm willing to agree upon an injunction different than going back to OSNI as long as the parties aren't waiving their rights in that regard. I don't understand that the court's denying our motion.
Let me clarify. The court has ruled that the non-compete is going to be held in abeyance. That's one measure of relief. You asked for 3. Those other 2 are not being granted at this time by the court. And in Michigan, what we do is when we submit an order to this effect, at the bottom below, above our signatures, we write, approved as to form, not as to substance, which is in effect a way of not waiving rights to seek alternative greater relief at the injunction.
Well, the order would only address what we've done here today, and then you would set it for hearing on the issues. But the order for today will read, I'm granting the TRO in where we do not enforce, you're restrained from enforcing the covenants not to compete.
We're putting the terms of the covenant in abeyance.
Right.
And Your Honor, the only thing I would clarify, so we don't end up back here tomorrow, is the relief we requested alternatively is to put the language of the covenant not to compete in advance, and under paragraph C, enjoining defendants, well, this is part of the same thing, enjoining defendants from enforcing any restrictive covenants, including the covenant not to compete, and not interfering with Dr. Einhorn's practice of medicine. So we can't just say, or I would submit to the court that the relief would be somewhat, well, it would at least result in a problem if it didn't make clear that the defendants are not to interfere with
Her practice of medicine.
A couple of things. Does the court have, just for the fun of it, 4 blank orders we can fill out before we leave today to make sure that the order, because this isn't going to be too complex, to make sure that the court, we can have an order entered before I have to come back on a hearing on this. I don't want there to be any misunderstandings on this point.
That's fine.
Yeah, we have something here.
The second thing, Your Honor, is it my understanding...
We'll find you something. We'll find it. We have.
The second point, Your Honor, is it my understanding that Indiana Rule 52 requires that the temporary restraining order contain findings of fact within it?
Well, if you want me to issue I think at the final hearing, I have to do findings and conclusions after the hearing.
Okay.
After the preliminary hearing, my ruling has to have findings and conclusions.
And for the purposes of that, Your Honor, has the court, I would ask the court just to articulate precisely what the findings are that have led to this ruling so we could just have a record on that point, Your Honor. And then in the order we could say for the reasons stated on the record.
Well, I think I've pretty much said I think that to preserve the status quo, that she can still practice medicine pending the final resolution or the hearing on the merits.
Okay. Your Honor, what's the court's ruling as to bond?
I'm sorry,
What is the ruling as to bond?
On the issue of bond, Your Honor, there is no showing that has been made by the plaintiff as to why bond would not apply. It is the standard in Indiana that bond be applied where a temporary restraining order is entered. There are no extraordinary...
What's your argument would be a sufficient bond?
From my perspective, Your Honor, the bond would be either the income that she receives as a, given that at this point the bond, your ruling is only that she is to not compete, or we're not to enforce the non-compete. Or interfere. Right. I would say that a fair bond, given the costs that are associated with having to respond, would be in the neighborhood of $15,000 a month.
There's no basis.
$15,000 a month, because we're talking about the costs that we have to respond, because
We don't know how many months it's going to be, do we?
Indiana law says that the purpose of the bond is to protect not the responding party, us, from the costs that we are incurring. And in fact, plaintiff's counsel, in his argument, talked about the costs that he would be subject to. So $15,000 a month on a non-compete case where we have a temporary restraining order and an injunction, Your Honor, is not an overreach. And I can proffer to the court with my hourly rate so that the court can understand where that number comes from.
Your Honor, as I addressed during my argument, Rule 65 requires bond to the extent that the court deems it appropriate. It's 65C. To the extent the court deems it appropriate to secure a party against whom TRO is issued from any damages or costs. As I said, as I argued, there are no damages that they would incur, and they haven't argued otherwise. There may be court costs, but any court costs would be something that the defendants could be awarded at the end of the trial, either through the arbitration or through the courts, depending on where each claim is heard. So $15,000 a month is without any basis, and it's outrageous. It would, in effect, be preventing Dr. Einhorn from practicing.
The alternative argument I could make, Your Honor, is if we want to talk about what relief we would be entitled to, is Dr. Einhorn could pay $250,000, which clearly is set forth in the contract as our relief, if she violates the non-compete. Because if she takes these actions in contravention of what the agreement says, then we have our claims under the non-compete. So it's one way or the other.
That's not accurate, because as I understand the TRO, and what we've asked for is to put the terms of the non-compete in advance until the parties' disputes can be resolved.
We'll set a bond of $10,000.
How much, Your Honor? And that would be in the form of security issued during the pendency of the entire injunction?
Yes.
So it wouldn't be the per month?
No.
$10,000? We'll prepare another.
Okay. Anything else?
Should we set a date for the preliminary injunction?
Yeah, that's what we're going to do now.
Your Honor, I have 4 physicians' schedules to work through. So if I could get maybe a handful of available dates on the back half of the 20 days.
Okay.
Further, Your Honor, on this issue of the non-interference portion of the court's order, so we're clear, it is so that Dr. Einhorn can go out and practice.
Well, let's try and draft an order together and see if we're...
Not to be involved in the practice of OSME. It's to have her own practice and do whatever she wants to do.
I'm only concerned by the vagueness of that. Does that mean Dr. Einhorn can't serve any of the patients that she served at OSME?
Patients can choose where they want to go.
Patients can choose where they want to go, but if she's coming and she's asking for the charts or she's asking for the business documents...
The treating physician has a legal obligation to have the patients.
Well, I mean, if the patient wants to see Dr. Einhorn, then they go get their chart, they have to turn them over, and they take it to Dr. Einhorn.
That's right, the patients ask, that's correct.
Your Honor?
Yes.
For the benefit of both parties, may I ask the court a question for clarification of the court's order? It is my understanding that under Rule 65, Section D, that any TRO or injunction has to be accompanied by findings of facts under Rule 52. Just so we don't trip up procedurally, I believe that what we're doing here is that both parties are presenting their proposed findings of facts and order. Parties will try to agree to the same language. In the event that the parties do not agree, I believe the procedure is that each party will submit their separate findings and order, and the court will decide which one is appropriate.
As of today's hearing, you're talking?
Yes, only as of today's hearing.
Well, I think that's probably the right way to proceed, but the only difference I suggest from what was said a little while ago, I'd like to go back and prepare a proposed order. I can either submit it to council or he can prepare a proposed order as well and we can exchange them, but I'd like to have a chance to go back and prepare a proposed order. If we agree, we'll submit it to Your Honor. If we don't agree, we'll each submit our proposed order.
The problem,
And I'd like to be able to do that by tomorrow at 1 o'clock.
the problem I have, Your Honor, is I really would like to walk out of here with an order so that in case there's any problem with my side or his side, we don't have Dr. Einhorn and my clients in limbo in
So
terms
you
of...
have so that answers your question. If you can sit down and agree on an order as to what I ruled on today, then that takes care of your concern?
My only concern was tripping up on a procedural issue of the requirement for findings under Rule 52 for the issuance of an injunction.
Well, what I would suggest then...
Well, aren't the findings, in fact, inclusions for granting of a permanent?
I'm sorry?
I mean, this is just temporary.
I would think if the parties concluded an order that they can agree on by saying the parties stipulate that this is sufficient for purposes of Rule 52, that would cover it.
That may cover it. Just to quote the sentence, every order granting temporary injunction and every restraining order shall include or be accompanied by findings as required by Rule 52, shall be specific in terms, shall describe in reasonable detail, and not by reference to the complaint.
All right, I mean,
But doesn't that... we may be off the record, but at this point, but will the court be available if we need to? Thank you. Let's see if we can get an order put together then.
let's see if we can get something that stipulates this.
As to the form of the order,
Yeah.
just so we're clear, I'm not stipulating to the relief, but stipulating
So
to...
if you want to submit findings and conclusions for each side,
That's how I prefer to do it. And we all each submit it by 1 o'clock tomorrow, and then Your Honor can, if there's an agreement, and Your Honor approves of the order, enter it, and if not, decide which order or some other order to enter. I mean, I think that's how...
this order is pretty simple.
I think it is pretty simple, and I think I would prefer that we just try to get it done before we walk out the door,
We'll
while we're
try.
here.
And Steve is correct. If the parties stipulate that this constitutes a proper order,
Then there's no,
then there's no issue.
okay.
Well, we have 48 hours from the date of the order to submit the findings.
To submit the what? Yes, you can. Okay, anything else?
No, thank you.
Let me get you some. Well, after 20 days, you need a few days. What is this, guardianship?
Yeah, let's also look at our calendars, just to find what's good for us.